Dear participants, a very hearty welcome to all of you. I request you to kindly mute your phones as well as put off your mobile phones during the program of the and also the mic. Okay. Now I request Ms. Prabhakar, President of KEA, to welcome and begin the webinar. Over to Ms. Prabhakar.
Thank you, Mr. Nagaraj. Ellarigu Shubha Sandhya. Good evening to all of you. Ladies and gentlemen, welcome to this Diamond Jubilee program, Series 6. I begin with a short introduction to Karnataka Employers Association. KEA, that is Karnataka Employers Association, began in the year 1961, has completed 60 years and celebrating its Shashtabdi Purti. Having crossed the milestones of Silver Jubilee in 1986-87 and Golden Jubilee in 2011-12, KEA stepped into Diamond Jubilee in 2021-22. Me having been associated with KEA since 1970, I have the proud privilege of witnessing KEA Silver Jubilee as well as Golden Jubilee celebrations. Now to be associated with the Diamond Jubilee celebrations, certainly a gift from heaven. I hope all of you are listening, are able to hear me.
Yes, sir. We are able to hear you.
We can hear you, sir. Thank you.
Thank you. KEA decided to celebrate its Diamond Jubilee in a befitting manner. I, along with the Working President Sri D.R. Nagaraj and Vice Presidents Sri Raj Pillai and Mrs. Pooja and KEA Secretariat, held elaborate discussions and decided that the best way to celebrate the Diamond Jubilee is to organize a series of programs for the benefit of our members who have been with us through thick and thin during the past 60 years. As the sixth of the series of programs, impact of recent judgments of High Courts and Supreme Court on management and HR has been arranged. This webinar is yet another value addition service offered by KEA to its members. The purpose of this webinar is to update the members on the latest interpretations of the labor laws by both Supreme Court and various high courts. Managements in general and HR fraternity in particular are in the front line of facing innumerable HR situations. Every day of the life of a HR professional brings new challenges. No doubt, they have adequate resources in terms of established practices as well as a wealth of court judgments which they can fall back upon. Despite this, the need for constant upgradation of knowledge for HR personnel is very much necessary. It is in this background that this webinar has been organized. Recent case laws from both Supreme Court and High Courts have been carefully chosen to highlight the latest thinking of the judiciary to solve the new HR problems faced by the new India. In short, this webinar will enable you to keep pace with the changing realities in the industrial sphere as seen from the prism of the Supreme Court and various high courts. But I'm happy that nearly 190 participants have registered, and this is really appreciable and encouragement to KEA. We have a distinguished panel of speakers who will share with you their presentations on several judgments that will impact the day-to-day functioning of the establishments. And Mr. D.R. Nagaraj, Working President of the Karnataka Employers Association, is another HR veteran with 50 years of experience, who will be the moderator for this webinar. Dr. R. Krishnamurthy, Director, International Institute of India, Mumbai, is a veteran in this field for 40 years, and she is a powerful speaker. She will be speaking on posh issues. She is Bharat Goyal Advocate, is a doyen of labor law in the country, and he, for past 4 decades, he has fought in the labor courts and high courts. I heartily welcome all of them, and I also welcome all of you for this webinar. And I am confident that all of you will get a lot of inputs, good inputs. Without much ado, I will now request dear Nagaraj, working president for Karnataka Employees Association, to take over the proceedings and continue further. Thank you all. Nagaraj. Unmute.
Nagaraj sir, you're on mute. You have to unmute yourself.
Thank you, Mr. Prabhakar. We are very happy in this Diamond Jubilee here. We have been able to conduct some very important and very useful seminars and webinars for our members and the HR fraternity. We continue to think and see what best inputs can be provided to our members. They are updated and they are able to handle the HR related, IR related issues in a very confident manner. Now, today's topic is in relation to the recent Supreme Court and High Court decisions which have impacted the managements as well as the HR. As you know, during the COVID and post-COVID situations, things have changed. There have been a lot of social vibrations taking place, which also influences the judiciary to some extent. So they would like to look at the cases which come before them, depending upon the kind of prevailing social situations, as also the prevailing labor laws. Some of them are fairly provide the path to the future. Extremely good judgments have come from Supreme Court, which has enabled both the organizations as well as the labor to modify their approaches. But some could create some issues within the organization between the management and labor, but it has to be managed. We are very happy that we have Dr. Krishnamurthy, who is a doyen in HR and IR matters, who is also the president of the Industrial Relations Association of India, to share with us the recent court decisions, both from High Court as well as from Supreme Court, and how they have impacted our management as well as our HR fraternity. Dr. Krishnamurthy brings rich experience of over 30-40 years in the field of IR and in the matter of labor matters. He has represented the managements in various cases relating to HR and IR issues, compliance under the labor laws, and handling of cases relating to indiscipline, etc. He is a retainer of many companies, including pharma, banking industry, IT-enabled industries, etc. He has been a trainer also in the field of IR and HR, and many multinational companies look forward to his inputs to enable them to manage their labor and labor-related issues. He also is a very good teacher. He is a visiting faculty in few of the very reputed institutes in management in Bombay, and he teaches issues relating to IR, labor laws, etc. He is also on the board of Nuclear Securities and Mega Private Limited. We are very happy to have you, Dr. Krishnamurthy. I am sure our members will get immense knowledge and inputs from your side, and they will have a benefit from your presentations. Now I request Dr. Krishnamurthy to start his presentation. Thank you.
Thank you very much, sir. It's a real pleasure, and I hope I'm audible.
Yeah.
Are you able to see the screen?
Yes.
Yes, sir.
Okay, thank you very much. I thank Mr. Nagaraj and Mr. Prabhakar for giving me the opportunity on behalf of the KEA to share my thoughts on the subject.
Recording in progress. Yes, sir.
The law and case law, there's an echo.
From your side.
So the law and case law on sexual harassment in the workplace. The changing case law has lessons for both members who are of the ICC, Internal Complaints Committee, and those in the HR profession. So when we discuss the subject, Mr. Prabhakar very nicely suggested that, why don't you speak on the recent case laws in prevention of sexual harassment by the Supreme Court and also High Court decisions. And he said that Bharat will speak on recent case laws, and he and Bharat will focus on some of the emerging trends in case laws that will be relevant for people in the field. So it was a real pleasure for me to be here with you and share with you some thoughts on the subject. The Indian environment, we know both Ramayana and Mahabharata have sexual harassment as the heart of a conflict and a battle to avenge the wrong committed. And we have seen many case laws that have been there in this subject. And prominent among them was the Vishaka judgment, which was called the landmark judgment in 1997, which very clearly defined the need for a law. And in 2013, we had the Prevention of Sexual Harassment in the Workplace Act. And this law was notified. And pursuant to the enactment of the law, any complaint of sexual harassment by women gets referred to the ICC. And if there's no ICC, it goes to the local complaints committee set up by the district committee. And it has to take cognizance of the complaint within 7 working days. And Act has very wide definition of terms such as employer, workplace, employee, and even an aggrieved person, not an employee, can prefer a complaint of sexual harassment against an employee. So sometimes, we have situation where somebody comes for an interview and that lady who is being interviewed may file a complaint. That has to also be taken cognizance by the ICC. And the ICC must be headed by a senior lady of the company and must have 50% membership of the women and must also have one NGO member. And quorum for the meetings is 3. The definition of sexual harassment is something similar to the definition of sexual harassment given in Vishaka judgment, where physical contact and advances, demand for sexual favors, making sexually colored remarks, or showing pornography, or any unwelcome physical or verbal or non-verbal conduct of a sexual nature. So some very important judgments, are relevant. And to me, these are all paradigm shifts that have taken place in the labor laws. And we need to take cognizance of such judgments. So the Supreme Court judgment in Vijay Kumaran versus Central University of Kerala. This is a 2020 judgment. On 28 January it came in. And it's a 3-bench judgment. And the judgment says that if there is a termination of employment, it is ex facie stigmatic. And then you have to follow the principles of natural justice, and the individual has to be given full opportunity to rebut the charges. And if that is not done, then the courts will give relief. And in this case, of course, the court found out that he was terminated and the opportunity for rebutting the charges was not given for him in the inquiry. And this is as per the service rules. And the UGC service rules very clearly stipulate that the manner in which the proceeding should be held. And it said that impugned termination was illegal, being ex facie stigmatic, as it had been issued without subjecting the appellant to a regular inquiry as per the service rules. On this conclusion, the appellant could stand reinstated. Now, this is something which is very important for us to understand. Reinstatement was awarded, but whether he should be granted back wages and other benefits, including placing him under suspension and proceeding against him by way of departmental or regular inquiry as per the service, was to be taken forward by the authority concerned in accordance with the law. So in this case, the appellant had challenged the order of termination. And the court had said that you have not conducted the inquiry which is required to be conducted as per your service rules. And I think in the universities, the service rules for teachers is very clear that you have to have a domestic inquiry before you terminate the employee concern. So this is a judgment by a 3-bench judge of Khanvilkar, Justice Hemant Gupte and Dinesh Maheshwari. This will have a bearing on other courts who are bound to follow this judgment if the matter is argued before them. This is considered a setback and an additional hurdle to be cleared and would delay the termination of those involved in offences of sexual harassment, as the ICC cannot ignore the implications of this judgment. Then there is also a Karnataka High Court judgment, Arabi versus Registrar of Mangalore University, which was on 20th July 2021, a very recent judgment, where the court has relied on the Vijay Kumaran case, and the petitioner in this writ petition calls in second show cause notice for terminating him from service. It appeared from the record that order that which places under suspension indicates the syndicate proposes to impose major punishment of dismissal. This was indicated in the second show cause notice as well. Second show cause notice also observes that in the event petitioner could not submit his reply, it would be presumed he had no representation to make. Both these orders unequivocally direct that decision was taken by a syndicate to dismiss petitioner from service. Dismissal being penalty under service rules in court considered view could not have been imposed without following procedures stipulated in rules empowering university to dismiss the petitioner from service. Thus, impugned show cause notice stands squashed. It was declared that no penalty could be imposed against the petitioner on the basis of a report of committee in terms of service rules of the university without holding any inquiry as obtained under the petition allowed. So the judgment, where the person concerned was punished to be bad in law. Then in Nisha Priya Bhatia case, now this is a judgment which Mr. B.C. Prabhakar shared with me and said that why don't you share this judgment also? And it's a very interesting judgment. The lady concerned was working with RAW, Research and Analysis Wing, which is a secret service agency of the Indian government. And she had complained, the bench of A.M. Khanvilkar and Dinesh Maheshwari upheld the compulsory retirement for former RAW agent who had leveled sexual harassment complaint against colleagues Ashok Chaturvedi, who was head of the department, and Sunil Luke on the ground of exposure having regard to the nature of work of the organization, of which confidentiality and secrecy are inalienable elements. The court, however, directed the center to pay within 6 weeks compensation quantified as 1 lakh for violation of her fundamental right to life and dignity as a result of improper handling of her complaint of sexual harassment. The court took note of the fact that in present case, appellant had faced exceedingly insensitive and undignified circumstances due to improper handling of her complaint of sexual harassment. Regardless of the outcome of the inquiry into the stated complaint, the fundamental rights of the petitioner had been clearly impinged. This lady had filed a complaint of sexual harassment against the secretary as well as assistant secretary. She alleged that a charge of subjected her to harassment by asking her to join the sex racket running inside the organization for securing quicker promotions, and upon refusal to oblige, she was subjected to persecution. The organization responded to the allegations after a gap of 3 months and by constituting a committee. And this committee also did not have an independent, NGO observer. That was rectified. But then the court found that this was not done as per the requirements of the Vishaka guidelines. And she was awarded compensation in the case. In the present case, the petitioner had faced exceedingly insensitive and undignified circumstances due to improper handling of the complaint of sexual harassment. So, compensation of 1 lakh has been ordered. Had it been a case of allegations in the stated complaint of the petitioner had been substantiated in duly conducted inquiry, it would have been still worse, and the accentuated violation of her fundamental rights warranting suitable compensation, higher compensation amount would be there. Be that as it may, the compensation amount specified herein above be paid to the petitioner directly or be deposited in the registry of this court within 6 weeks from today. The Nisha Priya Bhatia case is radical insofar as it expressly recognizes that regardless of whether the allegation is proved or not, a female employee may, as a matter of constitutional right, claim compensatory remedies from her employer for creation of a hostile environment at the workplace. Section 15 of the Act already provides for compensation payable to the lady, but for breach of her fundamental rights, compensation was awarded by the Supreme Court. Further, this is treated as a distinct violation from the conventional definition of sexual harassment as the commission of unwelcome sexual act, though the decision notes that the victim may claim a higher amount of compensation if such acts are proved. Then I will share with you a few other judgments, more in terms of giving you a perspective on how case law has shaped the law pertaining to conduct of the inquiry for investigating cases of sexual harassment. Choice of a neutral venue, right to have her mother attend the proceedings, writ jurisdiction of Delhi High Court, have independent NGO representative in the ICC. These are some of the points which were addressed. Stanislas Bern, MD of the Air France, reportedly harassed her sexually, and when she protested, she was threatened with immediate termination and forced to submit a resignation under threat, and she would be deprived of gratuity and PF. She resigned and lodged a complaint with the police and Women's Helpline and filed the police complaint at Gurgaon. Court held that Delhi High Court had jurisdiction as Air France also had her office at Delhi, and Gurgaon was not the only location where she could file the complaint. Inquiry to be held in neutral venue and not in the office of the company. She can take help of her mother, friend, or qualified psychiatrist. A member of the NGO must be a member of the ICC, failing which it is defective and illegal. On points of law, Delhi High Court and not necessarily the Haryana High Court had jurisdiction, and the Supreme Court judgment in Kusum Ingots was held to be valid. A new committee constituted by the court to hear the matter afresh and decide on merits. And this, you are not a victim for sharing your story. You are a survivor, setting the world on fire with your truth, and you never know who needs your light, your warmth, and raging courage. So this is a very laudatory reference to her fight against the company by the High Court. And the manner in which the rules, provide for conducting of the inquiry and based on principles of natural justice. So this is a very important requirement. And I think the committee ICC must pay deep attention to this provision of the rules as well as what is provided in the Act for complaint of sexual harassment. Mind you, the law is so powerful that even the complaint of sexual harassment against the Chief Justice of India had to be investigated. The Chief Justice held a hearing with 2 other judges and appointed a 3-member committee headed by senior-most judges Bobde and Lady Judge Indira Banerjee and Ramana to hear the complaint. The lady objected on ground that Ramana was a close friend of the CJI, and he recused himself, and another lady judge, Ms. Indu Malhotra, was appointed in his place. The bench held hearings. After 2 hearings, the lady refused to participate on the ground that the service of a lawyer were not provided to her, and she was intimidated, and the panel was hostile to her. This complaint was investigated the panel, which had held that the complaint of sexual harassment had not been proved. The lady had asked for a copy of a report, which was not given to her, but given to the registry, and the third most senior judge recused himself, Justice Mishra. Now, there are some judgments of the Supreme Court which are very path-breaking, and this judgment by which the tribunal and the division bench, quashed the teacher's termination. The apex court upheld the termination by the school and said that the tribunal as well as the High Court failed to appreciate the matter in correct perspective and also accepted the decision taken by the school management, which was not only fair and transparent, but was in keeping with what is expected of them when the allegations of sexual harassment of adolescent girls was involved. The High Court and the tribunal had followed the order in which the school had terminated the termination order was quashed by the High Court and the tribunal, but the Supreme Court said that no, the termination is valid. Then there's a very important judgment of the Delhi High Court, in Council of Scientific and Industrial Research, which says that, just every touch is not harassment. It's a very, very welcome judgment. Because very often situations are, police arrest the person concerned of sexual harassment, that you touched the lady concerned, you are offended her and unwelcome determined behavior. So he said that all physical cannot be termed as sexual harassment. Only physical contact in the nature of a sexual unwelcome sexually determined behavior would amount to sexual harassment. Then doctor's touch, not sexual harassment. Now, this is a very interesting judgment of the Bombay High Court, which, gave relief and quashed the FIR that was filed against the doctor because the patient complained that, his touch was inappropriate while administering injections. And, the compounder was present, her son was also present. And she made a complaint of sexual harassment against this, and 3 doctors of the JJ hospital said that this is the way treatment has to be given, and injection has to be given, into the flesh and not the nerve or the, artery or vein. You have to be careful in the injection because D3 and D12 injections were to be given. So it was held that the doctor's touch is not sexual harassment. And of course, Supreme Court judgment, in Meda Kotwal Lele, which was just before 2013, it was a 2012 judgment. It says that, in other words, the disciplinary authority shall treat the report findings of the complaint committee as findings in the disciplinary inquiry against a delinquent employee and shall act on the report accordingly. The findings and report of the complaint committee shall not be treated as mere preliminary investigation or inquiry leading to a disciplinary action, but shall be treated as finding report in the inquiry into the misconduct of the delinquent. Then there's a very path-breaking judgment also of Kolkata High Court, which talked about gender-neutral, approach to the act. The Kolkata High Court has said that the law was gender neutral and ICC could entertain complaints of harassment filed by individuals against persons of the same gender. So, you could also have a male complaining against a female or a male complaining against a male. That would be also heard under the act. And he said that the definition of the word respondent covers all and does not mean the person of the same gender cannot hurt the modesty or dignity as envisioned in the act. As men are excluded or not seen as they could be aggrieved under the point, there is no legal recourse if they are sexually harassed in a place. This judgment is a hopeful sign that judiciary is starting to move away from the deep-rooted heteronorm and could start the much-needed conversation about making gender-neutral laws on sexual harassment, rape, and gender-based violence. And then there's a very detailed procedure outlined in this judgment of Ashok Kumar Singh versus University of Delhi. You can my presentation will be circulated, to all of you. So please go through this. And then there's a division bench of the Madras High Court, where Justice Satyanarayana and Justice Hemlata held that the POSH Act cannot be misused and harass someone with exaggerated or non-existent allegations. Every office has to have a certain modicum of decorum, maintain a certain decorum. The administrative head or chief has the right to extract work, and he or she has his own prerogatives. If a woman is discriminated against due to her inefficiency or for any other official reason, the recourse for her is not to take one by this complaint. The case relates to a woman officer complained on December 2 to the registrar about high-handedness of the Superior Natarajan, about rude behavior and complaint of sexual harassment, and the complaint was filed before the state local committee and not the ICC, as she was not sure of justice there. The court admitted the writ plea against the order holding Natarajan guilty of sexual harassment, and it found that there were several procedural violations by the LCC. Copies of the complaint were not served on the respondent. The original complaint dated was generic in nature. It elaborated on how Natarajan was authoritative and biased in his actions and decisions, about his high-handedness and hurt to her self-respect due to his arrogant behavior. It was in a sharp contrast to the complaint on February 17. The latter did not mention about the date of the events or sequence of events, talked about physical advances by Natarajan and also his lewd remark on her physical appearance. The original complaint does not even give iota of what is stated in the latter. The committee concluded that there was prima facie case of sexual harassment and one complaint mentioned sexual harm without describing it. The bench observed that the complaint apparently was a futile attempt to settle a personal score with the petitioner, and a solitary allegation of intemperate language does not qualify as sexual harassment. And the court held that admonishing a person for a poor performance would not qualify to be sexual harassment. Now, I have just given a comparison of sexual harassment under domestic inquiry, the domestic inquiry conducted under the misconduct proceedings under the standing orders, and inquiry under the sexual harassment. Both are similar. Both are quasi-judicial proceedings, but here oath can be administered. And the power to summon witnesses and production of documents also is there, which is not there for domestic inquiries. And police may be asked to execute the summons. So this is a very powerful proceeding available for you, to compel the presence of the witnesses and also the complainant and the respondent. And the matter has to be heard within 90 days. As of now, no outsiders are allowed. And the inquiry is done by the ICC team. And I think that's very important And therefore, the ICC must be in a position to understand the law and appreciate what are the finer points of the law. And I hope some of the case laws that have been mentioned here, you go through it, and it will be useful if you keep them in mind when you conduct the inquiries. So with that, I will conclude. Thank you very much. Mr. Prabhakar, I think I have concluded the time frame which has been given to me. Thank you very much.
You have been able to clearly highlight some of the very important decisions and also the clarity you provided in many of these cases. It's very important because sometimes, due to the emotional reasons, employee could exaggerate some of the feelings and bring it under the Sexual Harassment Act. But as the courts have observed, that all things cannot be under the Sexual Harassment Act. Very nicely you have brought out. I'm sure some of our members will have many questions to ask. I request all the members to kindly note down your questions, and we'll have about 10 minutes question and answer session after the presentation by our another expert who is here with us, and then we can allow the questions to come. Now, friends, we have another very eminent person, Mr. Bharat Goyal, who is also from Bombay, to share his expertise on this matter. He has been a very senior person in the judicial field, have appeared in many cases, and particularly Godrej and Boys Manufacturing Company has been a legal advisor. He has been a legal advisor to several companies in Bombay and Maharashtra. He is also the vice president of the Industrial Relations Institute of India. He has addressed several IR and HR conferences and workshops, and giving the updates on the legal matters to his clients and many other HR and IR professionals. He is also an honorary member of the Executive Committee of the Employees Federation of India, which represents the interest of the employers all over the country. It is now my pleasure to request Mr. Bharat Goyal to kindly address the webinar. Mr. Bharat.
Yeah. A very good evening to all of you.
Good evening.
It gives me great pleasure to address the participants today in the webinar on this subject matter relating to the recent judgments of courts impacting management and human resources. When we have a look at the recent judgments given by courts, we find that the focus of the courts has been more on social justice and not on industrial equity or efficiency considerations. Now, these judgments basically have indicated a shift in judicial thinking so as to play a proactive role in administration of justice, keeping in mind the changed business environment. Now, I shall deal with two recent judgments of Bombay High Court, which have been given in the case of Bajaj Auto and Tata Motors, wherein the employers had been engaging employees as budlies, casuals, and temporaries with years and years together, and the objective was to deprive them the benefits of permanency. Now, the first case which has been given by the Honorable Bombay High Court has been in the case of Sunil Khomane versus Bajaj Auto. Now, interestingly, in the facts of this particular case, there were these employees who were engaged on a temporary basis for a maximum period of 7 months. Now, the employment would never go beyond 7 months, and there were breaks given to these employees. So these were termed as artificial breaks because other workmen were appointed in their place. So therefore, this led to a presumption that work existed throughout the year. Now, there was a pool of about 8,000 to 10,000 workmen, and none of the employees could complete this magic figure of 240 days as held by the High Court. So they were not allowed to complete 240 days of continuous service, as a result of which there were disputes and complaints of unfair labor practices filed against the employer. Now, the stand taken by the employer before the High Court was that this appointment is in the nature of a fixed term contract employment, and it falls within the exception to the definition of retrenchment, because it falls under section 200B of the ID Act. Now, this contention of the employer was repelled by the High Court, because the engagement of employees, what the High Court says is that when you engage employees on a fixed term basis, it is for some particular work or project or due to spurt in demand and the resultant need for increased activity, whereupon there is a special need for certain employees. So therefore, the engagement is for a particular work or project or for a fixed period. Now, in the facts of this case, the work was of a perennial nature and similar to the work performed by the permanent workmen. So a reasonable conclusion could be drawn that the engagements were not for a particular work or project, nor the engagements had come to an end for want of work upon expiry of the period of contract, because the work continued and there were other workmen engaged in the places of these temporary employees. So the court has taken a view that these engagements were by way of artificial breaks to avoid a legitimate claim of permanency, and it was a clear recipe of an unfair labor practice. Now, surprisingly, the labor court in this case had taken a view that there was no rotational pattern or there was no artificial intermittent breaks. Now, the High Court has termed this finding as perverse and basically offending the Wednesbury principles, that is the common law doctrine, that the decision of the labor court was so unreasonable that no reasonable authority could come to a conclusion, as a result of which the High Court had to interfere as far as the order of the labor court is concerned. Now, in this particular case, there was compensation which was awarded by the High Court, which was on the basis of 85 days wages for every completed year of service. And the minimum salary to be taken into account was at the rate of rupees 8,000. Now, in addition to that, a lump sum compensation was also awarded for a lump sum period of 3 years for the period after termination. So therefore, there was an additional salary directed to be paid for 255 days. Going further to the recent Tata Motors decision, which has been decided by the High Court, this is again on similar facts where the concerned employees were given appointment letters for not more than 7 months. So maximum it would be 210 days. And they were working in the core manufacturing activities of the company. Now, the company had taken a defense in its reply that there were peak seasons for which they were engaged, and there were lean seasons on account of which they were disengaged. Now, unfortunately, the company could not produce any documentary evidence to show the rise and fall in the production growth. So the court has taken a view that it was a case where the management has systematically prevented the temporaries from completing 240 days, and it was an involuntary unemployment foisted before they could complete the magic figure of 240 days, and a false case has been made out to show that the work has come to an end so as to fall within the ambit of section 200BB of the ID Act. Now, this was again a case because where the employers pleaded that we cannot grant reinstatement. So therefore, this is a case where lump sum compensation was awarded by the High Court based on each tenure of service, each tenure. So therefore, the term of 211 days, an employee would get 75,000 as compensation. Then different periods, then there were lower rates of compensation as prescribed. And the lowest compensation was in respect of an employee who has completed 60 days to 89 days, amounting to rupees 25,000. I'm sure all of you all have come across the recent decision of the Labor Court in respect of a software professional who was employed with Tata Consultancy Services and who was granted reinstatement with full back wages. Now, this particular judgment is in respect of one of the largest IT companies in our country, which would create an impact on the industry in respect of employment termination cases. Now, he joins the company as an assistant engineer, promoted over a period of time. He was an IT analyst, then an assistant consultant, then also the head of testing. Now, as per this employee, his jobs were of technical and clerical nature. Now, he contends that he was given a C rating. Subsequently, initially, he was given a performance B rating, which was higher. Then he was given a C rating due to the bell curve policy introduced by the company. So there were star performers who were identified, and there were low performers who were also identified. Now, according to this employee, his duties were skilled and technical in nature, and he was doing jobs of maintaining IT infrastructure, installing updates, business virtual machines on a monthly basis. He was involved in troubleshooting issues. Then he was monitoring the business virtual machines, installing software, etc. So these were the jobs which he performed according to him. Now, according to the company, the jobs performed by this employee were reviewing the performance of employees, work of employees to ensure their skills. Then he would provide guidance to project managers on the right strategy to be adopted for testing software solutions. Then, interestingly, he would also coach them in respect of reviews and assessments, and was required to take junior assessors along with him and coach them on assessment process. Now, when he was employed as a test manager, he was creating test strategies. He was reviewing the work of 5 test engineers. Now, according to the employer, to the company, there were 5 test engineers who were reporting to him, and he was directly responsible for supervising the 5 test engineers. Now, when evidence was led before the court, and then the court had to adjudicate into the claims made by the claimant, the court has taken a view that the appointment letter and the promotion letter did not contain the duties and responsibilities assigned to the petitioner. So therefore, we have to be mindful of the fact that any appointment letter or the promotion letter issued to the employee must contain the responsibilities which have been assigned to him. Now, the company also pleaded that he had other responsibilities. Now, it was not mentioned as to what were the other responsibilities. So therefore, the court has taken a view that it amounts to a subterfuge to camouflage the petitioner's principal nature of duties. Now, also in the pleadings, where the employer has used the words also empowered, also expected, he was also empowered to do such and such jobs, also expected to carry out these jobs, also provided the following jobs to be carried out by him. So the court has taken a view that these pleadings show that these jobs were incidental in nature to some principal duty which was assigned to the petitioner. So therefore, this ruling is basically an eye-opener to, in fact, all of us, not only to the HR professionals, but even to the lawyers when we draft our pleadings, because we have to be very specific and precise as far as our pleadings are concerned. Now, the court also took a view that the petitioner was in charge of a section which was a small one and which related to quality control, and this was an incidental duty performed by the petitioner. Now, with great respect to the observations made by the labor court, now even if he was supervising the work of 5 test engineers, it cannot be said that he's carrying out supervision of a small section. So therefore, even if he supervised the work of 2 people or 3 people, that itself was sufficient to come to a conclusion that he was predominantly doing supervisory duties. Now, the court takes a view that these supervisory duties performed were incidental in nature, and he would be a clerk and he cannot be converted as a supervisor. Now, we also need to know, basically be mindful of the fact that when the court takes a view that he was doing skilled jobs and the incidental jobs were coordination or giving advice or sharing his views, what is important is that the jobs of giving advice or sharing views or coaching or guiding the employees cannot fall within the ambit of the definition of a workman. But the court has somehow taken a view that these duties were incidental in nature, and the other jobs which he was doing, like giving advice, coaching, guiding the employees, was incidental in nature. Now, importantly, there are 4 rulings of the court which have not been taken into consideration by the labor court. One is the judgment of the Supreme Court in Sonepat Cooperative Sugar Mills, where the court has held that an employee can be said to be performing jobs of a clerical nature where he does stereotype jobs or monotonous jobs. But where he does not perform stereotype or monotonous jobs, his jobs require creativity, application of mind, mental inputs, calls for cerebral challenges, then he cannot fall within the inclusive portion of the definition of a workman. Now, we have another ruling given by our Honorable Bombay High Court, wherein in this particular case, the court has interpreted as to what are technical duties. So therefore, where he uses his technical knowledge, it cannot fall within the ambit of technical duties because he has to take a judgment in respect of the work, and this does not amount to technical duties. Now, the court has also held that where the employee has an authority to sit over and pass a judgment about the work, impliedly it falls within the ambit of supervisory function. Now, one of the facets of a supervisor as held by courts has been that he has to allot work to subordinates, he has to recommend leave, he has to appraise the performance of employees. So what our High Court has held that is one of the facets of supervisory work, and that is not the be-all and end-all of supervisory work. So therefore, supervision can be exercised in respect of quality of work, and also to come to a conclusion whether the jobs have been carried out as per the required guidelines and specifications, which would also fall within the ambit of supervisory work. So therefore, where you carry out technical duties, there is no scope for judging, opining, or evaluating. So the court goes further to say that it cannot be said that a duty to treat a patient is technical in nature, and hence a surgeon is doing technical jobs. The labor laws are meant for welfare of laborers, and if the labor courts under the labor laws waste their time in holding that doctors and engineers are laborers, it would be the most unfortunate state of affairs. Another judgment which has been ignored by the labor court has been the decision of Bombay High Court in Standard Chartered Bank versus Vandana Joshi, where the court has held that all managers may not have the power to appoint, dismiss, or sanction leave. The traditional tests which apply to a manufacturing business cannot be applied to business of software or biogenetics or a business at the cutting edge of technology. So the definition of a workman should be such that it should not stultify innovation, development, and change in managerial practice. So the business managers should have a high degree of latitude to promote efficiency. Now, many times what happens is that our opponents take a contention that whatever jobs the employee was doing was subject to verification or subject to instructions given to him by his superiors. So even if that is so, it will not mean that the concerned person falls within the definition of an employee, because there is no requirement of an absolute autonomy or absolute discretion for a person to be a manager. Now, the last judgment, which was also not considered by the Labor Court in the TCS judgment, was a decision in the case of Glaxo, which judgment of the single judge has been confirmed by the Supreme Court. Now, this was a case where an industrial relations executive claimed that he is a workman. Now, this industrial relations executive fell within the lowest rung of the management cadre, which comprised the head of HR, followed by senior manager HR, followed by manager HR, and then the lowest position was the industrial relations executive. Now, the court has taken a view that even this employee in the lowest rung was involved in initiating steps, mooting proposals, or making suggestions which would have a direct impact on industrial relations, and it would be held that he is a part of the management cadre. So therefore, the employee was a part of the team which shaped the policies of the company, and he was therefore a part and parcel of the management, and he certainly fell within the administrative and managerial capacity and was not a workman as defined under the Industrial Disputes Act. Now, the court also referred to the earlier decision of the Supreme Court in Burma Shell's case, which was reported in the year 1971, wherein it held that the work of giving advice and guidance cannot be work of a technical nature. I'll also like to draw your attention to some significant judgments given by the apex court and the high courts in our country in the last 2 to 3 years on labor laws. Now, very interestingly, was a very innovative view taken by the MP High Court in the case of Novartis in respect of a sales promotion employee. Now, the court has taken a view, despite the fact that there is a deeming provision under Section 6(2) of the Sales Promotion Employees Act, that the provisions of the ID Act will apply to sales promotion employees. The court has taken a view that basically a medical representative works independently in the field and there is no supervision of his work. So he is therefore the master of the work assigned to him, and he carries out the work solely at his discretion. Now, he does not supervise any person, but he is still the master of his own affairs in respect of quantification of sales, and therefore he cannot be treated to be a workman within the meaning of Section 2S of the ID Act. And the court has referred to the decision in the case of Adhyantya versus Sandoz, which was delivered by the apex court way back in 1994 and has arrived at this finding. Now, no doubt this judgment has been challenged by the Federation of Medical Representatives and it is pending in the Supreme Court. Now, another interesting case has been given recently by the Delhi High Court, which is in case of abandonment of service. Now, you are all aware that in case of abandonment of service, the settled law has been that you cannot infer abandonment of service And in respect of abandonment of service, you have to hold an inquiry, you have to charge sheet the employee and hold an inquiry. But there has been a departure from the thinking of the courts on this point, where the court has taken a view that if the employer does not himself consider abandonment of service as a misconduct, then the law cannot force him to consider such abandonment as a misconduct and hold an inquiry. An inquiry is required to be held only where an employer intends to impose punishment on the employee for an alleged misconduct. Now, in respect of disputes of contract labor, now we have this judgment of the Chennai Port Trust, where the employees employed in the canteen were supervised and controlled by the principal employer. Now, in the facts of this case, where the court observed that there was absolute supervision and effective control exercised by the principal employer on the contract labor, including electricity, water, etc., provided free of cost by the principal employer, then the contractors changing, but the contract labor still continuing, the court has come to a conclusion that the supervision, control, and direction was of the principal employer, and the court, while arriving at the finding, has referred to its earlier decision in the case of Indian Petrochemical Corporation Limited versus Shramik Sena, delivered in 1999. Now, as far as grant of back wages is concerned, now it has been a settled position of law that where the termination of services of an employee is illegal, the necessary concomitant which follows is that he's entitled to full back wages. So that is a rule and not an exception. But there has been a departure in terms of thinking of courts, where courts have taken a view that an employee has no right to claim back wages. Claim of back wages is now an exception and not a rule. And the court has considered the earlier decisions of the Supreme Court in UP State Brassware Corporation and Deepali Gundu Survase's case, which were delivered by the Supreme Court in 2006 and 2013. Then another judgment of the Supreme Court has been in the case of closure of an establishment. Now, where there is applicability of the provisions of Chapter 5B, which says that it applies to an establishment wherein 100 or more workmen are employed. So the status of each and every employee has to be examined by cogent evidence, and the nature of duties of each workman has to be considered. So therefore, contract labor, if there are contract employees who are engaged by contractors, they have to be excluded from the limit of 100, applicability of 100 workmen. Then in the case of this most recent judgment in Telema Electronics, delivered by the Supreme Court has taken a view that traveling allowance or conveyance allowance does not fall within the definition of wages under the ESI Act. There is no difference between conveyance allowance and traveling allowance. And therefore, if you include conveyance allowance on the basis that it is being paid every month to an employee to meet his conveyance expenses, it is an erroneous construction of the definition of wages under the ESI Act. And the Supreme Court has considered its earlier ruling given in the year 2021. Then in the case of this particular judgment given by the Delhi High Court in HDFC Bank most recently, this is on the point of territorial jurisdiction. Now, many times what happens is that there are clauses in appointment letters that the jurisdiction will be at the place which is specified in the appointment letter. Now, in this particular case, the situs of employment of the concerned employee was in Delhi. She was employed in Delhi. The letter was served on her in Delhi. So the substantial cause of action had arisen in Delhi. But the letter of appointment had stipulated that in respect of any disputes, the cause of action will be at Mumbai. Now, the court has taken a view that the jurisdiction of the Delhi court is not completely ousted by the jurisdiction clause, and it has referred to its earlier decision in the case of Vishal Gupta versus L&T Finance. So these have been some of the most interesting judgments given by the Supreme Court and High Courts in the last 2 to 3 years. So while I conclude my session, I would just like to mention that today, the employers as well as the HR professionals are required to be well versed with judicial pronouncements of courts so that their actions are well founded and in conformity with the provisions of law. So this would be necessary to mitigate any risks, including filing of legal proceedings and any reputational damages against the employers. I thank all of you for giving me this opportunity to speak in the webinar. Thank you so much.
Thank you, Mr. Goel. You have been very, very clear, specific, and were able to provide the participants with many of the recent court decisions which are of some consequence, particularly appointment of casual labor or contract labor, or mentioning the duties when you promote a person. Some of these things are very, very clear. Many of the HR professionals may not take these kinds of issues seriously and then get into problems. You have been very kind enough to highlight some of these issues. I'm sure our participants would have immensely benefited from your presentation. I also got a lot of inputs from your presentation, and I sincerely thank you, Mr. Goel, for that. Before we conclude, we have also a presentation by Mr. Prabhakar. Sorry. I request Mr. Prabhakar to kindly share his presentation. Mr. Prabhakar.
Thank you, Nagaraj. Thank you, Nagaraj. In fact, friends, I would be sharing a few judgments, mostly of Karnataka High Court and Chennai High Court, which are the recent cases which are bearing on the day-to-day operations in the industry. See, once again, our High Court has held in the Hindustan latex case that tiny is not a workman. And second, 2 years of the ID Act, it excludes, and the court clearly said tiny have accepted the terms and conditions mentioned in their contract of employment that he would have no right to claim permanent status, and tiny apprentice have no right to claim regularization or permanent status even he was performing the work of regular nature. A very good, important case, Hindustan Latex, Belgaum, versus Employees Association and also General Manager Hindustan Latex, reported in 2002 LNR 400. In fact, another judgment important is employees supervise the work of 2 persons, not workmen. Mr. Bharat Goel also mentioned about this. Employees supervising the work of 2 persons working under him and drawing wages more than 10,000 per month will be supervisor, not a workman. These express publications, Madurai, Lenin Kumar Ray, 2002 LLR 630, Orissa High Court. And another case of supervisor is employee drawing salary more than the prescribed limit and doing duty of supervisor nature has resulted to him in his appointment is not a workman under the ID Act. In this case, health inspector doing supervisory sanitary work, including water supply, waste disposal, drainage, and overall cleanliness of various places in the premises, the management held to be not a workman. One important case of Manipal University, Manipal versus Sri Suraj, Karnataka High Court decision, recent decision, misconduct of disobedience, insubordination, and repeated negligence in performing duty would justify the management dismissal. In this case, non-vacating the quarter by an employee despite repeated express orders of the management is a gross and serious misconduct, and therefore the punishment dismissal is upheld. Very interesting case of Supreme Court recent in Bata case, ghost law, pro rata payment upheld by the Supreme Court. Ghost law is an intentional reference to work by the workman, and the management would be justified in reducing or paying pro rata basis only after giving opportunity of paying. Inquiry is not necessary, it's to give you opportunity. Management can also take disciplinary action since such a misconduct which will be serious nature because workers remain present at workplace without doing any work. So therefore, you can also pay proportional wages and also take disciplinary action and punish him also. And often a question is raised, can we give different punishment to different workmen? Is it an unfair labor practice? So in the case of Toyota Kirloskar Motor, our High Court has held it is not so. Punishment dismissal is justified to a workman who caused damages to the property of the company, including dents to the cars of the factory. It held punishment may be imposed differently on different workmen on the basis of gravity of misconduct committed by each workman. Imposing punishment upon a workman and let go the other would not be unfair labor practice. The charges against both of them are different in nature. Different punishment to different workmen on the basis of the different misconduct is either discrimination or victimization. This is a very good, important case for us. Transfer workers to far off place, it is not permissible. In the Chennai case, 3 out of 7 workers were transferred over 1,200 kilometers away, did not have knowledge of Hindi, and transfer is malafide and via victimization and vindictive. This is the Madras High Court case. So transferring within the state or best is in the neighboring state may be permissible, but not to different state, to far off states. And prosecution without impeding company not succlaim. This is very important case. In fact, left and right nowadays, prosecution are being sanctioned. In this case, a prosecution was sanctioned second the ID Act because company was alleged to have violated different the terms of settlement. And while prosecuting, if you prosecute only the director or individual manager without impeding the company, without also making company the accused, the prosecution can be quashed. That is Karnataka High Court judgment in Ramesh Mehra versus Umesh Nanda. It's 2002-11-618, very recent decision, very important case. And another important judgment is nowadays what is happening is people by the entry to agreement take money and then again raise the dispute. This in this case it is clearly held. The workman filed a suit, and in the suit settlement was entered into between the management and the workman services were terminated. The workman and the advocate signed settlement, and workman received the amount of 4,24,000 as agreed in settlement, and he also returned the laptop. Then interesting thing is he raised a dispute with the labor court, and he filed an affidavit alleging that his advocate, he made alleging advocate, became passive acknowledger to the order of the court date 29/9/2012, which recorded settlement. Court records settlement where advocate of the workman also agreed for the settlement. On rejection of his claim, the workman challenged the same. The labor court did not accept his allegation and dismissed his case. He went to High Court. In the High Court, very interesting observation is there. High Court held that the allegation sounds imputation against the court itself. A sanctity is attached to the proceedings of the court. Advocate is an officer of the court. There is statutory presumption under section 104 of the Evidence Act that the judicial acts are regularly performed. High Court held when there is a termination of mutual settlement, it is not open to the workman to question the same. Workman cannot be permitted to approbate and reprobate. This is the case between Vijay Ganpati versus Intuit Technology Services, very recently decided by our High Court. And nowadays we are getting a lot of prosecution by Labor Department, and some of the prosecutions are filed after 3 months. And in the recent case pertaining to Vineet Agarwal, occupier of Wipro Enterprises, our High Court has held, since the prosecution was filed beyond 3 months after the knowledge came, after the inspector came to have voted, it was not within the within section 106 of the Factories Act, where it says that it should be filed within 3 months. It was time barred, and it dismissed the prosecution And the High Court relied on the judgment of Supreme Court in J.G. Irani and State of Jharkhand. Here it is to Supreme Court 3735 and judgment of High Court of Jharkhand in another case. It was relied upon and prosecution was quashed. And with regard to gratuity, various questions are coming. Therefore, I included this also. See, gratuity is payable to a workman under section 272 of the Payment of Gratuity Act, and it should be paid within 30 days, as per section 7.3. And if you don't pay within 30 days, whether he has made a claim or not, it is the duty of the employer to pay the gratuity even without a request. And if you are not paid, then you are liable to pay interest beyond 30 days at the rate of 10%. So this is the case of Karnataka High Court in the case of Verma Industrials versus Jankiram Shetty, recent judgment. In fact, for payment of gratuity, whether daily wage period has to be considered. Our High Court held in the case of Chief Executive Officer Jilla Parishad Mysuru versus KEA Puttraju that the workman before confirmation had worked as daily wage worker, and that period has to be taken for the purpose of Gratuity Act. And forfeiture of gratuity. In fact, in the case of any resignation or dismissal, you can forfeit the gratuity, but our court, in fact, the Chhattisgarh court has held that you must issue a notice before forfeiture. Without issuing notice and asking him explanation, and if you pass forfeiture order, it is not valid. So therefore, you must issue notice and he has to give explanation. You must consider, then pass an order, then you can forfeit. If termination is for righteous or dissolved behavior conduct, any other act of violence for any act constituting an offense involving multiple gratuity may be fully forfeited. And in the case of loss or damage, it can be forfeited to the extent of the loss or damage. This is what Chhattisgarh High Court has held. A report recently in 2002 LLR 641. Nowadays, we are getting a lot of EPF orders under section 70A. What they do is they pass the order and immediately attach the bank account. Sometimes the order will not be received by the management at all, and we get the attachment order. So the Madras High Court has held, without serving the order in the management and issuing attachment or bank attachment, attaching the bank account is not permissible. It was quashed. And further, it is also held by Madras High Court that when appeal is filed before the tribunal, before the EPF Public Tribunal, there is pendency appeal, attachment order cannot be issued. So if such an order has been issued, it can be quashed. Very recent case, today morning, all of you must have read in the newspaper, Dharwad High Court Division Bench in the case of Grasim Industries has upheld the amendment to certified standing orders from 58 years to 60 years. And all the contentions urged by the company relating to working in hazardous industry, and also there is a clause in settlement that they can't raise the dispute involving financial burden. It cannot be during that period you cannot raise the retirement age because it imposes a financial burden. High Court has rejected that. In fact, we used to take all these contentions. 5 contentions they have discussed elaborately and rejected. In fact, the High Court became philosophical. Judges quoted Shukraniti, treatise on governance, and said that low salary, harsh treatment, insults, and imposition of penalties are causes of unrest among employees. Satisfied with adequate wages, promoted honorably, and cheered by gentle words, employees would never desert their king. So In fact, various contentions which they have rejected all show that the judges have had made up their mind to increase the retirement age to 60 years, and they have given reasonings which are contrary to judgment laid down in the Supreme Court. I don't know whether Grasim Industries is going to appeal to Supreme Court or not. But as of Karnataka is concerned, the retirement age, if workers file an application for amendment to the standing orders, there is no way that we can resist it. So standing orders will be amended. So therefore, the resistance to the age of retirement standing orders may not be sustainable. These are the few judgments I wanted to share with you. So thank you all. Time given to me is up to 6:10. I completed within 6:10. Thank you all.
Thank you, Mr. Prabhakar. You were also able to bring out some of the recent court decisions which have impacted both the management and HR. Looking at the three presentations, I feel that there are a lot of issues which require a lot of clarity, and Supreme Courts and local high courts and labor courts have been providing their thoughts and ideas. Sometimes it provides clarity, sometimes it may cause some within the industry some problems, but these are some of the things which we have to manage. I'm very, very happy that all the three, Dr. Krishnamurthy, Mr. Goyal and Mr. Prabhakar, were able to highlight very important cases in the last 4, 5, 10 years, recently particularly. I'm also very happy that we had over 200 participants in this webinar, and many of them have asked questions, and Krishnamurthy and Goyal have been able to respond to them. Now, if anybody has any questions, you can raise your hands and then tell your name. We'll allow about 5 questions to be asked. The rest of the questions you may send through chat box. They will be able to respond. So kindly raise your hand and ask the question. Please mention your name and the company and to whom the question is addressed. Over to the participants. Hello. Participants, photo. Mic on. Kavita, you had a question. I see that. Kavita.
Good evening, sir. My name is Reggie.
Yes,
and
please.
the question is to Mr. Prabhakar. Sir, is this you've quoted a judgment regarding the increasing of retirement age to from 58 to 60. What you mean to say is that standing orders which has already got a retirement age of 58 can be increased to 60 by application by the workman?
In fact, if the workman union files an application to amend the standing orders from 58 to 60, first it has to be dealt with the certifying authority, and certifying authority in view of the judgment will overrule all your objections. But some objections you are taking, all those objections have been negatived by the court. He has no choice except to allow the amendment. He will allow the amendment. Once he has allowed the amendment, so we have got to follow that. Of course, there is appeal and also again that writ petition. But in view of this judgment, none of the contentions will survive. So therefore, if certificate standing order is amended, you have no other choice except to follow that.
Okay, sir.
Palani.
Hello.
Yeah.
Yeah, sir, my name is Jyoti. I'm from SB Cable India Limited. I have one question. Like, sir shows one slide. ESIC should not be include conveyance allowance or traveling allowance. That how we have to follow. This is the amendment or just that court judgment?
Bharat Goyal, begin.
Yes. See,
Mr. Goyal?
basically, if you see the definition of wages, so it excludes conveyance allowance. So the view taken by the court, Supreme Court, a year back in that Texmaco, the Industries Limited judgment, was that it will not fall within the ambit of the definition of wages. So if employers have been basically including that, it requires to be excluded. It will not fall within the definition of wages under the ESI Act. So this view has been again confirmed by the most recent judgment of the Supreme Court just last month, which I just brought to your notice some time back.
Thank you, Mr. Goyal. Yeah.
Sir, my name is Sujan, sir. I'm from Bhuj Unit, Ramco Industry. My question to Sir Prabhakar, sir. Sir, the retirement age you have mentioned increased to 60, sir. But in the PF, sir, EPS is restricted up to 58, sir. The EPS contribution will be restricted to 58, no, sir?
So what is the question?
The question is that EPS, that pension contribution,
EPS.
Will be restricted to 58, sir, because in the PF Act, it is mentioned, sir.
PF is 58.
Under the PF Act,
Sir.
Yes.
increase in pension and
Pension scheme, if you are 58, automatically it stops. You
in
have
fact, as far as the retirement age may be say more than 58, but as far as the pension is concerned, the contribution to pension will stop at 58. And the pension amount which you are paying to the pension fund will have to be included in the PF subscription, and that will go as PF, not as pension. So this retirement age increase has no bearing on pension contribution.
The PF can continue, sir, up to 60.
Pardon?
The PF deduction can continue, sir, but pension deduction will be stopped.
You can
In fact, he can continue because the retirement age is enhanced, but pension has to be stopped. It has to be included in the PF.
Okay, sir.
Mr. Prabhakar, I have one question to you. If the labor union has 50 to 58 to 60, the labor court agrees. If the management has reduced from 60 to 58, will they agree?
60 to 58.
Yes.
In fact, the outstanding orders provide up to 60, and whether management can raise a issue, it should be 58 for specific reasons. Yes, it can be done, because the word used is maybe, not must. Depending upon the facts of the case, is open to reduce it's open for the company to reduce the retirement age, but we have to make out a strong case. It is permissible.
Good. Matthew?
Good evening. This is Matthew from Hidden Wings. It's a fundamental question. This is with reference to the gratuity thing. So are companies kind of duty bound to pay gratuity within?
Sir, good evening.
Hello.
Sir, good evening.
Mr. Matthew,
Hello?
please continue.
Yeah. So I was asking, is the company duty bound to pay the gratuity? Even let's say if it is a startup and they are going in losses, right? So are they duty bound to pay gratuity? Number one. And number two, if a startup has changed a company or the employee from different entities, but they were working for the same management, in that case, would that be a continuous service of employment?
Yes.
In fact, there are two parts of the question. One is startup and loss, no exemption. Is only number of years of service. Employees commit 5 years of service eligible for gratuity. Whether loss or profit is not the criteria, you got to pay. Secondly, if there is a change in the legal entity,
first.
whether changeover has taken place as whether it provides for continuity of service or not. If it is if there is a change of employer, just because there is change of employer, the service will not come down because there are succession interest. If that is the case, then you have got to count previous service with the previous entity and pay the gratuity.
Right, sir. And the last question, again, with related to this, if it is a gratuity, the employer has to claim it, or is it a duty bound after 5 years, or on the resignation after 5 years, they are duty bound to pay? Is employer need to apply for gratuity?
Consider the employee ceases to be employee, then within 30 days, you have got to pay on your own. Whether it makes the application or not, you have got to pay. If you don't pay within 30 days, from 31st day onwards, you have to pay interest 10% on that.
Thank you, sir. Thank you so much.
Right, friends.
Sir, good evening. Sir, good evening, sir.
Who is it?
This is Palani, HR from this Kali Ishwari refinery.
Okay, last
This
question.
could be
Yeah.
slightly,
Yes.
this could be
Please
slightly
continue.
different, but this question is to our Mr. Prabhakar, sir. Sir, we have one plant at, this could be slightly deviation from our regular discussion, but we have got one plant at Chennai where we manufacture, where we do a refining of edible oil. Now at the back side, we propose to add this biodiesel plant also, but that will be in the different name. But only thing is the common facilities like EB, pollution, this STP, ETP, all that will be from this existing unit. Is it acceptable? Or is there?
What is the question, Palani?
Sir, I'll repeat. We have got one existing.
No, what is
factory.
the question? Question, please tell the question.
Question is it allowed?
Which
Can
one?
it be done like that?
You can start a new entity in the same premises, but if there is function integrity between the two factories, then it will raise other issues under the Industrial Disputes Act. Even if you maintain separate balance sheet, separate payroll and all those things, for the purpose of combining the strength, for the purpose of Chapter 5 of the ID Act, the layoff return closure, those will be clubbed if there is a functional integrality. So you can have any number of one premises, no issue. But labor law application, practice of application, it will be clubbed.
Thank you, Mr. Prabhakar. No, sir, we'll close it because it's time for us.
Mr. Nagaraj, sorry to ask you a last question.
New plant.
No, any
sorry,
question?
Sir, can I be allowed to continue, sir? Sorry. Sir,
just this is on the gratuity.
Sir,
this is on the gratuity.
Palani,
I have not got it here.
Please
sir,
stop.
I request to talk for 1 more minute.
Kindly send it through the chat, your question.
Sir, I request for 1 more minute.
Please kindly send it through chat, Mr. Palani. Last question, Mr. Venkatesh.
Yeah, sorry, this is again on the gratuity part of it. On the recent labor code which is released, the gratuity period stands the same year, same period, Mr. Prabhakar?
So under the new labor code also, same provisions continue. No change.
No change.
Yeah.
Thank you. Thank you.
Okay. Fine. I could see the interest our members have and the questions they have.
Hello.
It is understandable. Kindly excuse us because we have to close by 6:30. So therefore, it is my great pleasure to conclude this webinar. We are very grateful to Dr. Krishnamurthy and Mr. Goyal, as also Mr. Prabhakar, for sharing the concepts as well as the decisions of the recent Supreme Court and High Courts. Some of them are very, very revealing, and some of them provide a lot of inputs to the HR and IR managers to see what kind of precautions they should take, ensure that there is justice and they are following the laws without any problem to the organization. I have the great pleasure now to request Ms. Prabhakar to extend our warm thanks to Dr. Krishnamurthy and Mr. Bharat Goyal through a presentation of our memento, Diamond Jubilee memento. Mr. Prabhakar and Krishnamurthy first.
Dr. Krishnamurthy, it's a pleasure to give you a memento. So we will virtually present it to you and we will send it to you through courier. Please accept our memento.
Enough money.
Thank you very much, sir.
Thank you. Thank you.
Thank you, sir.
Mr. Bharat, we are also giving you a memento. Please accept it. Virtually, please accept it and we will send it to you by courier.
Thank you so much. Thank you very much.
Thank you. Nagaraj, over to you.
Dr. Krishnamurthy and Mr. Bharat Goel, your immense knowledge, your lot of treasury of knowledge with you, which will be very, very useful. And we will be troubling you quite often to share your knowledge and experience with our members. And I'm sure our members have immensely benefited from your inputs. Thanks also to Mr. Prabhakar, who was able to share some of the latest concepts and decisions of our high courts. All the three of you have done a great job, and I'm sure our members have benefited. So with that, we'll be closing the webinar. Thank you all participants for your kind presence. Thank you.
Thank you, Nagaraj, and thank you, Prabhakar, sir. Thank you very much.
My pleasure,
Thanks.
sir.
Thank you, everyone. Thank you.
Thank you, everyone.
In fact, some of the companies have shared up to 24 people. Chris Corp has deputed 24, Ramco 10 participants, Automotive Axle 8, and Silver Spark Raymonds have deputed 7 people. So it has evoked a lot of interest. The very webinar heading has interested all the people, and I'm happy that all the speakers have contributed well for the success of this webinar. Thank you all.
The topic is very interesting, that's why. Yeah. Thank you, sir. Thank you.
Thank you very much.
Close.
Thanks, Bharat.
Thanks. Thanks, Doctor. Thank you.
Thank you.
Sir,